Good morning, everybody. This is Greg Reese, founder and CEO of AmeriEstate Legal Plan. Thanks for joining us. This is kind of a follow-up to just a great little webinar we did about a month ago with Jimmy Smith, one of our prominent estate planning attorneys, and Shauna Wekherlien, the tax goddess and national tax strategist. And if you attended the previous webinar, we had so much interest and so many questions coming out about estate planning and taxes and tax strategies and things like that, that we wanted to extend and do a follow-up. And today we hope to do a lot of live questions that you can talk to the professionals and the experts here and get some general answers. We also want to do a little bit of an update on the Build Back Better legislation that's working its way through Congress, to determine if there's any impact that we should be aware of in mid-December for year end. And so, with that being said, welcome, Jimmy. Great to see you again.
Good morning, everybody.
Welcome. Thank you so much for joining us. I wanted to note that if you have any questions, please use the chat box. And then we'll go through these questions kind of on a first come, first serve basis. I think what we can't really dive into too much today is if you have a personal, estate problem or issue that you want to work through, or a very personalized tax structure. What do I do about this? Here's my numbers. What's my answer? We're happy to take your feedback by emailing us, chatting us. We'll keep records of stuff. You can follow up with us individually. We'll route you to the right professional depending on your question. But I also want you to keep in mind that this is a Zoom call. There's going to be a couple hundred people participating. So you probably don't want to share your personal dirty laundry with 200 witnesses. Okay, so maybe that's just a confidentiality thing. But having said that, just keep that in mind. And we may not be able to get to all of your questions today, but certainly we can try to address them on the back end if necessary. So let's kind of kick in. So don't forget, use the chat button. Give us some of your questions. And but here, first thing I think I'd like to do is let's just get that Build Back Better thing out of the way right now. Where is that? Jimmy, Sean, I'd like both of your perspective. From Jimmy, your perspective, from an estate planning perspective, is there anything about this Build Back Better plan? Where is it? Is it going to pass? Is there anything that we need to be aware of? And then Shauna, maybe right after that, you can let us know your perspective from a tax strategist point of view. Jimmy?
Well, based on that question, we're still kind of in a crystal ball place, but the way that it looks, it does not appear that it will pass, given all of the estate planning situations that were shoved into it. When we last met, there were a lot of things that concerned me as well as a lot of other people about the estate tax exemption, about grantor trusts. A lot of things could have fallen away, which would have impacted people greatly. That stuff has all been removed from the bill for now. Now, it could always come back. It could always be readdressed next year, but it doesn't look like the exemption's going to be messed with. It's actually going up. So I think that we should be in pretty good shape on in that perspective.
And hi. And that, of course, then rolls into the tax end. One of the biggest things on the tax side was that estate tax exemption, right? So if we've got those big estates, are they going to get taxed? But same thing, if that bill is not going to pass, all of our rules for 2021 are staying exactly where they are, thank goodness. Now, we are seeing a lot of Twitter on the internet about we're trying to push this, we're really trying to get this through, we're really trying to, on and on and on. But they're saying December 28th. In all likelihood, there's no way this thing's going to pass.
They'll all take some vacation time and leave us alone. Is that what you're saying? That might be nice.
Oh, darn.
It's always the uncertainty, I think, that drives people crazy. So, all right, well, good. Well, listen, I'm going to start with a couple questions that have come in, and I'm going to flip it a little bit, depending on where it seems to be most appropriate. You both might have a take on it, but one of the opening questions that we got was, from an estate planning side. What happens if we don't have a will or a living trust?
If you don't have a will or a living trust, then basically you pass away intestate. So what'll happen is that the intestacy statutes in California You would have a personal representative that would either come forward or be assigned, and your estate will pass to your heirs at law. Basically, what that means is that what assets you have would go through probate. You would be paying attorney's fees based upon that. There would be an executor would also get fees based upon statute. And then think of it like a tree. First off, it goes down to the roots. Your children would be your heirs. If you have no children, it continues down to grandchildren. If you have no grandchildren, if there's none going down that way, it goes up. The tree goes up to your parents. If you have no surviving parents, the branches start to come out. What would happen is it goes to your siblings. No siblings, then we start to look at nieces and nephews, and you can see how it continues on out. But you have no control over it, and somebody will be appointed to deal with your intestate succession.
What about the families, Jimmy, that have minor children? How does, they're not assets, right? But how does that get resolved?
It'll be resolved by the judge. You're going to have to end up with a trust situation in some way, because your minor children, they're not going to take a 9-year-old and put $300,000 into their hands. So you end up with a testamentary trust that's basically done through the probate.
Good, but what about the children themselves? Do they go to the orphanage? Social services steps in? What happens to them personally?
Well, the issues are going to be family. I mean, if you've got family members that come in and they will petition the court for guardianship over these minor children, and they'll go, hopefully, if deemed fit, then they'll have loving families to go to. If not, then the state would come in.
And the state, they get to kind of make the ultimate decision too, right?
They're going to make the ultimate decision anyway.
So, for example, if somebody comes in that petitions for guardianship and they're the last person you would personally choose, it's possible that without planning, somebody could be raising their kids that they wouldn't otherwise want to have that responsibility?
Correct. Unless someone else comes through and deems these people unfit. So the court only has so much information, it's got to be provided from somewhere.
Right. Very good. And then same thing with kind of the estate and the legacy and the inheritance. If you leave it up to the state law, chances are people could receive assets of yours that maybe you wouldn't have chosen to leave to them, right?
If you have no children and you have a wayward brother that you really don't care for, that brother's going to share just like the sister you love. It's going to be an equal distribution as the state determines who your natural heirs are.
So it sounds like planning versus no planning, there could be some serious consequences, right? I mean, just the guardianship issues,
Oh, yeah.
And unintended heirs issues.
Well, you lose control. And if you want control, the issues extend much further than just saving some money. You do lose control in the ability to deal with your families in the way that you deem appropriate. All of a sudden, again, the court gets it, and it's a pretty black and white situation.
Good. Well, thanks for sharing that. Let me shift to a kind of a tax-oriented question here, Shauna. People oftentimes get confused about capital gains taxes and estate taxes. And, one of the questions that kind of came up, which was specific, was please address the capital gains tax repercussions on heirs inheriting fixed property from a living trust.
Great question. So one of the big questions is, well, how big was the estate in the first place? Okay, so if somebody passes away, and let's just say they're a single person for right now. So under the current law, they pass away, the current estate tax exemption is 11.58 million. So if that was mom, and mom originally bought her house for $100,000, and when she passes away, that house is now worth 1 million. If that was the only thing in her estate, the basis in the house that goes to the child is now $1 million. There's going to be a step up in basis on death. So the question about capital gains really then comes in for the child. Well, if the child got the house from the estate at $1 million and they sat on it for another 20 years, and now it's worth $10 million, there's going to be a capital gain on the difference between the 1 million and the 10 million. So that question is a very big, broad question. And it really does come down to kind of the specifics. But let's take the opposite example. Okay. Let's say the estate was worth 20 million. single person, and the total estate exemption still 11.5, the house might get a step up in basis. They should get a step up in basis to the fair market value on death, but the estate is going to have to pay taxes on that amount above the 11.58 million. So again, for the child who now has this $1 million home, well, did you turn around and sell it right away? In which case there's probably not a lot of gain to even pay tax on. Or did you sit on it for 20 years and now you've got the difference between the 1 million and the 20 million now that you're selling it?
And part of what I get from what you're saying is, let's say you had bought that house originally for 200,000, and when you passed away, it's worth $1 million.
Mhm.
If your child then inherits it and wants to sell it right away at that $1 million, from a capital gains perspective, would they pay any tax?
No. So, well, I mean, other than the markets are going absolutely insane right now, and between the day you inherited and 2 weeks later when you sell it, there might be some gain. But yeah, if it's the same day, if it's happening on the exact same day, exact same time, whatever you inherited for it and you're selling it for, there should be zero gain because your basis, what you inherited it for and what you're selling it for, are identical. So there should be zero gain.
So another question, tax related, just want to keep it in this vein for a second. There are some assets that we might have in our estates that may be subject to tax to our heirs, and others that aren't subject to, like income taxes or capital gain. I'm not talking about the estate inheritance taxes right now, but what types of assets might we pass on that still might be subject to some tax, and what types of assets are generally not subject to income taxes and related?
Oh, that's a big question. Okay, so your typical hard assets, okay, stocks, houses, cryptocurrency, gold, those kinds of things, typically will not have income tax. So of course, there's 20 different types of tax, right? There's capital gains tax, income tax, net investment earned tax, AMT tax, right? There's a million different types of taxes. So typically, when somebody's giving a hard asset, they're not going to have income taxes on that. Typically that's going to be a capital gains tax. But income taxes, let's say it is stock. So you have the stock gets moved to the child, but the stock, like Chevron, is kicking off dividends. Okay, well, those dividends on the stock you now own might have income tax on them, depending on what else is going on your return, personal return for the child. Right. So really kind of a big question, again, depending. The world of tax is always an it depends kind of answer, right? But
right. So, but we want to kind of keep it as simple as we can for people. I know there's a lot of complexity because I keep thinking there's 72 types of taxes, but maybe I'm being a little bit overbroad. But as a general statement, though, inheritance in general is not taxable. But what about my IRA and 401k that I'm leaving to my kids? What about those? Do they get a step up in basis on that, or how does that work?
Yeah, normally not. Normally what happens is on death, you're going to be forced to take distributions out of that account. And generally those distributions are now going to be taxable as ordinary income. So it's a strange, you're absolutely correct. That one is a very strange, bad loophole in the code there, but it is what it is. If that's what you inherit, then you pay the proper tax based on the type of income that you're now receiving, which is a distribution from a retirement account.
Okay, so the distributions is what's taxed. It's not, oh, I left $1 million in my IRA. It's not an immediate tax on $1 million.
Correct.
But to the extent I take that $1 million, and let's say I take it in equal parts over 10 years, I'll pay tax incrementally as I take it out, right?
Correct. And each type of IRA, for example, has different requirements on, can it be, is it 5 years? Is it 10 years? You can have a choice. Some people take it out all at once and pay tax on everything. So there are some choices there. There are some cool rollover type programs that you can do as well. Sometimes they're called stretch IRAs, those kinds of things, but those typically come into play. We go back to the first question we talked about today, which is with proper planning. If you did no planning, there's probably not a lot of choice there. You get what you get and you pay tax when you get it. So.
Okay. So Jimmy, related question, related topic. So one of the questions that really has come up quite a bit from our first session is when people are doing their estate planning and they're creating their living trust, for example, they've got their IRAs and their 401ks. people are, and we know that the rules around IRAs and stuff have changed in the last couple of years. As a general statement, I know this is going to be a big can of worms and complicated too, but in general, people are asking, should my living trust be the named beneficiary on my qualified plans, my 401ks and my IRAs, or should individuals like my spouse or children be directly named on those instruments? What do you say about that?
Okay, that again, it really, it depends, but I will tell you that trusts now are created that you can have these IRA pass-throughs to the children, and you can protect them and have them put in their own retirement vehicles. There are a lot of different types of retirement accounts. You kind of have to know what that creature is and whether or not it's beneficial for you. Look, if someone comes to me and they have two children who are in their 40s and they have their children named as the contingent beneficiary past their spouse, and they say, should I direct this to my trust? And I'm like, is there a particular reason that you would want this distributed differently than outright to your children? I would generally say it's perfectly okay to have a direct beneficiary designation. When you are looking at issues where you have, again, when you come to minor children, obviously you need this to come to the trust. If you have handicapped beneficiaries, you need it to come to the trust. Handicapped beneficiaries who are on public assistance like SSI, where you don't want to upset that SSI. Those are situations you need it to come into the trust. And there are a lot of different reasons to bring them to the trust, too numerous really to go fully into right now. But if you do have a situation that's not really cut and dry, that's where we need to sit down and talk about what it is, where you have your money, what type of retirement vehicle it is, and the best way, whether or not bringing it into the trust and having it distributed through the trust is the best way. But it doesn't hurt to bring it to the trust.
And is there any differentiation between like adult and capable children versus minor children when you're doing your planning? And do you change it if you have minor kids and they become 18 or older? Do you change it? Is there a general rule of thumb there?
No, it does. If it's going to the trust because they're minor children, again, it depends on the retirement vehicle. So it's not really just a broad brush thing. But if you direct it to the trust when they're minor children and you never change that, I don't think you're going to, in general, you're not going to have a big problem with that. But sometimes it can be easier just to direct it to the adult child if that works for your family and your situation.
Okay, and a follow up to that, I like to find a thread and follow it through a little bit sometimes. But with regard to naming beneficiaries on these types of plans, and life insurance, comes in, and annuities come into the same play. They're treated often very much the same. Folks are asking, is it advisable to name IRA beneficiaries per stirpe? So maybe we have a quick discussion about primary and contingent beneficiaries, and is it advisable, somebody wants to know, to use per stirpes? And maybe you can explain what per stirpes is for the rest of the audience that don't read the law books like you and I.
Well, per stirpes designation means it's going to go down to your heirs. So it's your children. If you do not have a surviving child, it goes to your grandchildren. And if one child is deceased, their children will stand in their place. So let's say you have a daughter and a son. It's a 50-50 split. Your son is deceased. He has 3 children. Your daughter gets 50%. 50% goes down to the 3 children and continue down to great-grandchildren. That's a per stirpes designation. And generally, that is the way that it goes. Again, it just depends upon your situation. But primarily, you want your spouse to be the primary beneficiary with your children, especially with the ERISA qualified plans. If you have a situation where you have a retirement vehicle, it's a marriage that was done late in life. You each have your own families. You want your children to benefit from your retirement vehicle. There may be an ERISA requirement that your spouse has to waive their rights. So whatever you do, go to the administrator of your retirement vehicle and find out if it's ERISA qualified, if you're going to direct it to anyone other than your spouse. And then get the waivers done, because the waiver is either going to have to be done while you're living, or the waiver will be done after you're gone, and a spouse may or may not sign the waiver at that point in time. It'd be entirely up to them.
That's really great to know, Jimmy, because I've experienced since we do business in so many different states and in different tax laws and treatments that in some states you cannot skip your spouse when naming a beneficiary to one of these instruments. If you do, they can challenge it and usually prevail in certain states. So it's very important to talk to your legal counsel, talk to the plan administrator if you have any designs to leave IRAs, life insurance, these types of things to anybody other than your spouse, right?
You can't skip your spouse without their permission. So you can get them to waive their rights. And that's why that's a discussion to have during life and not just say, I'm going to leave it to my kids and then, have it worked out later. Have that discussion earlier.
Okay. And then one more just question that related to this that occurs to me. How often does it happen where mom and dad will name their son-in-law or daughter-in-law as a partial beneficiary or contingent beneficiary to their stuff? How often does that happen? Is that
in my practice? Rarely. Generally speaking, when the discussion comes and a spouse is included, it depends on the age of the child, the natural child. It depends on the ages of the children and how long the spouse has been around. If they're going to name the spouse, you generally find if they're younger and you lose a child younger who's married, that spouse, depending upon children and things like that in the family, may not be a part of your life 10 years later or 5 years later. So usually we leave it within the nuclear family. And then if you do lose the child and you believe after time that you do want to include the in-law, then call us and then we generally will do it at that point in time. Once in a while, but not a lot, is the in-law included immediately.
Okay, so that's a worthy discussion for people to consider, for you out there that are contemplating, doing your estate planning or updating your estate planning, and you've got these family dynamics. It's an important consideration, I think, to talk about when you do speak with your attorney. Here's kind of an interesting one, Shauna. This is going to, familiar with Section 721 exchanges?
Yeah.
Of course you are.
Benefits of being a goddess, honey. Come on. Hello.
Yeah, no, of course. I'm just teasing you up. Martin is asking regarding the 721 exchange, could dollars be put into a REIT, parked, and used later to buy active real estate?
Yeah, so it's a really good question. So typically what happens is, just for anybody who doesn't know what a 721 is, there are typically four or five different ways to get out of paying tax on the sale of something big. Okay, so within real estate, that looks like a 1031, a 721. Okay, both of those are real estate only. You can go from real estate or real estate to REIT, which is what the 721 is. Of course, you also have the deferred sales trust. You also have opportunity zone funds, right? So there are some other options here. But a 721 generally is real estate into a REIT. Now, this is a great question, Martin, because I believe it can be done, but I have never actually seen it done. Most of the people that go from a piece of real estate into a REIT using a 721 are typically doing it because they want to be done with real estate. They don't want to do the 2 a.m. plumbing telephone calls anymore, right? They want out. They want the real estate benefits, right, of the growth in the markets and these kinds of things, but they don't want to be an active manager of real estate. So I do believe that it can be done, but I've never actually seen it done. So Greg, I'm actually bouncing this question back to you. If somebody has their stuff in a REIT, from one of these exchanges, so we had real estate, we moved it to REIT, could we move it from the REIT into the DST when they take it out of the REIT? Because then they could invest through the DST, I would think.
I didn't know I was going to get questions too. All right.
Sorry, Greg.
Yeah, so there are often alternative ways to accomplish your goal, and that's why I love working with Shauna and Jimmy, because it's they're very creative. They find out what your objective is and figure out the proper legal way to get it done. And so that question is sort of around that. And yes, if you're in a REIT, you've exchanged into it through Section 721. And then it's run its course and you want to get out and buy more active real estate. In other words, you take a break from being a landlord. Now you're ready to get back in, I suppose. So yeah, a 1031 exchange might not work. It might work, but it might not work. But an alternative vehicle might be what's known as a deferred sales trust, which is specialized proprietary tax structure that allows you to sell any form of appreciated asset and reposition the proceeds on a tax deferred basis into any other asset classes. So you're not actually even limited to real estate, although real estate's an option, right? So yeah, there's more than one way to do that. So even if that 1031, 721 scenario wasn't appropriate for you, there's another way to go about it. So thanks for that. Thanks for that question. Trying to look and see what the next question here is.
Side note, everyone, we apologize for using acronyms. We will get better about it. The downsides to being on a webinar with a tax CPA and trust attorneys and all, we apologize. We will stop using acronyms, or at least explain the acronyms. So sorry, all.
Yeah, that's funny you said that, because a couple questions just popped up.
Yep.
What is a REIT? A REIT, REIT, is an acronym for Real Estate Investment Trust, which is a way to invest passively into real estate, into like a syndication, more or less, where you've got people that put together a big project in apartments or commercial buildings or industrial or something like that, all professionally managed, and you just contribute money to the investment, and they manage it all and distribute income to you. And when they decide to sell, not you, when they decide to sell, then you'll get your share of the profits. And so that's what a REIT is, a DST, or deferred sales trust. That's the acronym for deferred sales trust, not to be confused with another passive real estate offering called the Delaware Statutory Trust. Both strategies.
Those evil East Coasters. Come on, the West Coast is better.
They're different, but they have the same acronym, so that can tend to cause some confusion from time to time. While we're on the subject of real estate, now I'm trying to decide if this is a personal case or just a good general question for everybody. But really, I think it's a tax question, but it's a California specific question. So maybe Jimmy, maybe you both have some input here, because in California, we have what's known as Prop 13. Prop 13 generally would allow your family to inherit your real estate and keep the property tax base at the same level that you had it. So if I paid $100,000 for my house, my property tax will go up incrementally over time. But if my house is worth $1 million, on a $100,000 acquisition, my property tax is $1,000 a year. But if my property appreciates to $1 million, and let's say I sell it, guy buys it for $1 million, his property taxes are $10,000 a year. But then incrementally it goes up very small, so it kind of allows people to kind of stay in their house and not get taxed out of their room and board, right, so to speak. Now we've kind of gotten rid of Prop 13 last year, and so there's a different tax treatment. So this person, Ralph, is asking, my mom has several old rental properties in her trust, low property taxes because low basis, they bought them really cheap and they're worth a lot more now. And upon her passing, the properties are to be given to the children. So the intent is not to sell the properties when she dies, but to distribute them, to her children. They're investment properties, keep in mind, and they indicate they don't want to displace the renters, nor do they particularly want to raise the rent. What can be done to maintain the properties as rentals without incurring higher property taxes? And separate question, really, could we leave them in the trust and collect the rent as income instead? So in other words, I pass away, can the property stay in my trust and my kids collect the income? That's kind of part two of this question, I suppose. So let's deal with this Prop 13 that got radically overhauled last year. What happens when I want my children to keep the real estate that I leave behind?
In order for any of the Prop 13, in order to take the benefits that Prop 13 had given you with the way the laws have changed, the child's going to have to reside there. It's not going to be rental property and not be subject to the reassessment. That's the short answer with regards to the change in the laws. If there's something extremely specific about these properties, again, this probably isn't the forum to delve that deeply into something like that. But generally, it's got to go to your child. The child's going to have to reside there. If it's going to remain a rental property, it's going to be subject to reassessment. My understanding from the legal side of it. Now, there may be another tax answer to that, though.
That's a very good short answer because it can get complicated, but bottom line is if your children want to inherit real estate from you, in order to keep your low property tax basis in California, keep in mind this is California specific, they have to live there. Otherwise, if they keep it or hold it or turn it into a rental, it could even be your home you lived in, but they want to keep it and hold it as a rental. They're not going to get to keep your low, my example, $1,000 a year property tax bill. If it's worth $1 million, they're more likely to be paying $10,000 a year in property taxes, which kind of goes to part of the question here, Ralph. If you're not going to raise the rent on the tenants, you're going to be kids going to be shooting themselves in the foot because it's almost like giving your tenant free money. And if you haven't been that generous with your own kids, just think about that for a second.
Now, of course, the tax brain's coming in saying, woo, there's always a plan for something, always a plan for something.
Exactly.
I mean, I think the big thing here is that this question is very much looking at this in a vacuum, right? I'm only looking at the rental properties, okay? If a child now inherits 10 rental properties, they now have a business, according to the IRS. And if you have a business, there's 1,000,001 tax write-offs that you can take. Yes, fine, the property taxes are going to go up. Can we offset? Let's say it is $10,000 by 10 properties, so $100,000 increase in your expenses. Is there something I can do on the tax planning side to reduce my overall taxes by $100,000 and at least get me back to the same spot? So depending on how old these properties are, you might be looking at cost segregation. You might be looking at some low-income housing credits. I know it's California, so maybe not. You might be looking at creating a property management company. You have your own business to property manage these properties, which would allow you to pay your kids, write off the master's exemption. There's a million other tax deductions that you can do. So I guess my thought would be don't panic, right? Look at what other options, tax plans, different angles can you come into to try to get yourself back to at least break even. So,
oh, excellent. That is fascinating, Shauna. And so it's 10 properties. It constitutes now it's classified as a business.
Correct.
Doesn't matter what the value is. You could have 10 really small condos, and that's the same as 10 commercial buildings or a combination of different things.
Yeah, I mean, 10 commercial buildings certainly is very clearly a business, but the IRS defines a business in real estate at 3 properties or more. So if you've got 3 rentals, you have a rental business, right? Now there's goods and bads. Anytime it comes to the IRS, there's goods and there's bads, okay? And so what you're looking at from a tax planning angle is, well, how do I outweigh those bads with those goods, right? So that's why you talk with a tax strategist. So.
Right. Well, you just triggered another question. Somebody says, okay, if I have 3 properties and it's now considered a business, can I still do 1031 exchanges on any of those properties and qualify?
Absolutely. Absolutely can. Yeah, 1031 business owners do 1031s all the time. It's not restricted just to a private owner. It's perfectly fine.
Because it's different than, say, like being a developer who's in the business of buying, developing, and
Slightly
selling off the property,
yeah.
right?
Because in this case, your business is rentals, right? Your business is not building from scratch. Your business is not remodeling. Your business is the business of rentals. So you're okay.
That's a great differentiation right there, because that comes up so much in my business. Always trying to figure out, are you a dealer? Are you a developer? Because a developer would normally pay ordinary income taxes as they sell off the project that they built, right?
Yep, because that's how they make money. It's self-employment taxes. Right. So they're going to have to pay that extra 15.3. It's really nasty if you're considered a developer.
So no different than owning a grocery store or a manufacturing business or a service company or something like that.
Yep.
Developers are kind of treated the same way.
Yeah.
But okay, great. Now I'm going to go a little offbeat here with a question for Jimmy, just because it's kind of interesting. So one of our sons was a sperm donor. That's how it starts. Can the many children born from that situation sue for any part of the inheritance?
Okay.
I don't get this question very often, let me tell
And
you.
it really doesn't find its way into my practice very often, but I will tell you that generally speaking, that's taken care of by contract with regards to donating the sperm. And there is no legal relationship between the donor and the child. Without that legal relationship, there should be no claim against the estate. The caveat there is whether or not a legal relationship is created later between the donor and the child. For whatever reason, they become a part of their life. And I guess certain things can be done. But generally speaking, it's a straight contractual thing, and any of that liability should have been addressed within the contract before the donation was made. Okay.
So read the contract before you donate.
Correct.
Please.
That's a good idea. And I know that, within a living trust and a pour over will environment, you're typically listing the names of your children. So you don't have to say, if you're a sperm donor, does 1 through 29, right? In addition to John, Sally, and Stephen, right?
But that brings up another issue. A lot of people tend to want to forget about the bad seed, and they will say, well, I have 2 children, and they actually have 3 children, but they haven't seen a child in 30 years. And this is a child that was naturally born or legally adopted and does have a legal claim against the estate. In that case, just make sure that whatever you do when you're doing your estate planning, list all of your natural born and legally adopted children. The sperm donor stuff, nothing about that. Stepchildren don't need to be listed if you're no longer married. If you're divorced or widowed and you had stepchildren in the marriage, they don't have a legal claim against your estate, but the natural born and legally adopted do. In California, there's a statute, that's what's known as a pretermitted heir. So what people don't understand is when you pretend they don't exist, California can allow them to come in and claim not that you were trying to get rid of them, but that they were forgotten about. And that can bring them right back into your estate on equal footing. So the best thing to do, acknowledge all of those children. The ones that you do not want to participate, let us handle that. Let the lawyer handle that. Essentially, we will disinherit them. We can do it strictly. We can do it nicely, whatever the situation is. But what it does is you're not there to testify at when this becomes relevant. And because you're not there to testify, a judge is looking to intent. If I have in the trust, I acknowledge that little Janie exists and she is not to participate in distribution, it tells the judge what your intent is. If little Janie is never mentioned, little Janie can use the pretermitted heir statute, come in and claim she was forgotten about, and she should have her legal share. So again, that's kind of an aside from the original question, but yes, you do need to name those children. The sperm donor situation, if it is still anonymous and per the contract and you haven't avoided that contract in any way, I wouldn't really worry so much about that. But again, I'm not privy to what the contract is. You're going to have to do the work on that. Very
good. Well, that was a maybe a first for me. I don't know that I've gotten that question in the past. You think you've heard it all until you haven't, right? On a related topic, Jimmy, traditionally, it's always been sort of folks in the later stages of life that think about doing their estate planning and getting a trust put together and so on and so forth. But really over the last 20 plus years since we've been working together, we're seeing the average ages come way down dramatically. So now we have younger professionals and young families understanding how important it is to create an estate plan. And one of the main triggers often is the fact that they have minor children. And it's so important to be able to designate their guardian, who's going to raise them if something happens to you, and also who's going to manage your financial resources for their benefit while they're growing up and when they're old enough to be responsible for the money. But there's something that people forget to review and update. What happens if I create a living trust, my wife and I, and we've got a 3-year-old baby girl who's just the joy of our life, and we get our trust done and we think we're all set, and then another baby boy comes along next year. If he's not in our trust, what happens?
Well, if he's not provided for in the trust, everything's going to go to baby girl, but you can have that pretermitted heir issue come up, and but then you get courts involved. So there are ways that this can be remedied, especially if a judge sees that you had one child when the trust was created, you had another child later, the child has not been disinherited for whatever reason by amendment. But again, the term is judge. You can't come to me and I can't wave a magic wand as an attorney, but I can certainly charge money to go to court to deal with these issues and hopefully work it out the way you would have wanted it. But again, you're not there to testify, so they don't know what exactly you would have wanted. So it's always best to revisit. Take a look at your estate plan. I'm not going to tell you to do it every month, but every few years or every 5 years, take a look at what's going on. And if you've had a very serious change in your life, whether it's a birth or a death or drugs have infested the family in some way and something has happened, if there's something life-changing like that, take it down the trust binder. Let's take a look at it and let's see if anything needs to be done. Okay.
Yeah. So reviewing your estate plan is kind of like maintaining your vehicle, your car. There's a service schedule, but in estate planning, it's event driven, right? It's not based on how many miles you got on that chassis. It's based on events, all the things you just mentioned. So good reminder for everybody out there: changes in your life, changes in the status of your family, conditions that occur that are favorable or unfavorable that might have an impact on your estate or how you would want your affairs managed or distributed. What if you named your parent as your trustee of your trust and now you're 70 years old and your parents are 89, 93, are they still the best choice to manage your estate, or are they expected to outlive you? All those kinds of things come into play. So thanks for that. Here's a tax question here. Somebody's asking, what would the tax liability be for large savings accounts if the child is the beneficiary? Savings accounts, large savings accounts.
It's a good question. What would the tax liability be? I mean, the child's going to inherit, assuming we're under the estate exemption, right? The child's going to inherit the savings account. The child would only then pay tax on any of those dividends or earnings or interest payouts or whatever it is from that type of savings account. So maybe I misunderstood the question.
From the date they inherit forward. Yeah. So
from the date they inherit forward.
I think the question is going towards, if my child inherits a large savings account, are they going to be subject to tax just by virtue of inheriting the savings account?
So the inheritance itself, and I think that's kind of going back to your earlier question, and people always get confused about this, right? The inheritance is one thing. Once you have it, it is now yours. That's a whole different thing, right? The way I always think about it is the government's going to get their cut in every time something switches hands. Every time, right? So the government has their inheritance, you have an exemption, it's over, it's under, we're going to pay tax, we're going to do whatever. Whatever happens there it happens there. Then it's going to move to the child. Once the child has it, whatever happens there, and it now ties to that child.
Okay, very, very good. Another possibly a tax-related question, and this, I think we all know the concept of like snowbirds, people that live in multiple states at different parts of the year. You might live in Wisconsin, love it there, but winter's not so great, so you got a place in Arizona, to spend the winters and then go back, in the summers to Wisconsin. Are there any tax rules associated with people that kind of are that snowbird kind of mentality? They live part-time in one state versus another. Is there anything particular we should know about?
Did you see the big grin face hit my face? Yes. So it depends, right? Which state, how long are you there? So we have some people that move between 3 states for 3 different seasons, right? Each state has their own set of rules. Now, what I can say, since y'all are in California, I'm in Arizona, right? California is a giant octopus, right? If you even breathe into the state of California, they will tax you on something. That's how that's going to work, right? But it absolutely depends on the state. Nevada, Wyoming, Florida, Texas, there's lots of states that don't even have taxes in the first place. So you may want to set up your primary residence in one of the non-tax states and then live in those other states for the least amount of time, the most amount of time you're allowed to live without triggering that you now become a resident for that state or pay tax to that state. So it absolutely depends on which states you're looking at.
And does every state kind of have that 6 months and 1 day rule, or is it different in different states?
Every single state is different. Many of them go with 6 months and a day, but some of them say 10 days. California is very nasty about it. If you earn income in California for 10 days or more, you're now in California. It's very different across the states. So highly, highly recommend that you work with your CPA to go look at which states are you in and how long are you there and when do you need to skedaddle, right? Get out, right? So
that's great information too, because I always encounter people that just assume 6 months and 1 day rules where you're a tax-paying resident, right? But that's not necessarily
most of the super high tax states, New York, New Jersey, Pennsylvania, California, right? Most of the super high tax state rates are going to try to get you as fast as possible, right? Because they want that 10% for them for the 11 days that you're in that state. So yeah, definitely double check.
Yeah, I see, there's states where there's a lot of migration out of and a lot of states where there's migration into. So talk about California, it's one of those states. A lot of people are more people are leaving the state than are coming into the state. But a lot of those people want to keep a foothold, because they always say in real estate in California, since it's relatively expensive relative to most parts of the country, that if you sell your California real estate and leave, good luck coming back and buying again, because the prices are going to be that much higher. So you move to Arkansas, beautiful lakes in the Ozarks or something like that, and you want to come back to California, may not be able to afford it anymore. But so that's great information, Sean. Thanks for that. Another estate related question. Folks want to know, is there a grace period or any kind of statutory limit to how long you can take to settle a living trust when somebody passes away?
No, it's going to be no. And that's because some living trusts are set up to go on for years. The only thing I can tell you is the outside date is the rule against perpetuities, which basically would be 21 years after the death of someone alive when you die. And it's kind of an arcane rule. It's a malpractice trap, basically. You can't keep a living trust open forever, but it doesn't have to necessarily be cleared up in 2 months. You have the successor trustee has to have a reasonable time to make sure that all of the bills have been received, the bills have been paid, any administrative expenses, taxes, Shauna, they'll take their pound of flesh too. And everybody's got to be dealt with before you distribute. So many times you'll have heirs that will come in and say, well, hey, mom and dad have been gone for 2 months now. Give me some money. I want a car. And I would advise the successor trustee that unless everything's been done, don't do that. Because if you do that, then if you don't have enough money left to do it, you're the one who's responsible for it. And it's very difficult to get a beneficiary to disgorge money once you've already given it to them and it's spent. So be careful. But that being said, you can't just sit on the piece of property for 3 years because you decided that you don't want to sell it, or you're emotionally attached to something, or you're angry with your sister. You do have to do it reasonably, or they can file papers to have you removed as the trustee. You do have a fiduciary duty.
I want to say here, and I'm just the tax person, I'm not the attorney, so I'm sure you guys have seen a lot worse cases than I have, but I have seen cases where one child is in control and they say, yeah, I'm getting to it, I'm working on it, right? And if you have to file papers or lawsuit or whatever, this can drag on for years and years, right? So it's not supposed to take that long, but I've seen cases that are
Right.
so.
And that's what I'm talking about. It needs to be reasonable. You can't unreasonably not distribute to the heirs of the estate. But then on the other side, the heirs have to be reasonable with you to allow you time to pay all the bills, to take care of all the expenses, to make sure that everything's done, tied up in that nice, neat little bow, and then start cutting checks out. The only thing, on a case-by-case basis, if there's plenty of cash to go around and a successor trustee wants to make a small distribution and it's not really going to impact what's going on, they can certainly do that as well. They can manage the estate based upon the estate. It is a case-by-case basis.
Perfect. Now, just along that same line, we all know that probate is sort of that court supervised process. If you don't have a trust, you have no estate plan at all, or you just simply have a last will and testament, that's just an e-ticket ride to the probate court. And depending on the state or the jurisdiction, that can take 9 months to 2 years to settle before any of the heirs get anything or even much communication, where a living trust is intended to have the ability to be settled in a much quicker fashion. So we're talking a little bit about some of the outlying cases where people are trying to be, controlling or stubborn or what have you. But in general, how long do most fairly straightforward living trusts take to settle, where it's all wrapped up, administratively by the trustee?
Well, in a hot real estate market, and if you have all of your ducks in a row, 3 or 4 months maybe, it just depends on to make sure it's all paid. I would say 3 to 6 months is not unreasonable at all.
Okay.
And again, the thing about when you're going to court, you're not making the decision any longer. The judge, there are judges, there are probate referees, there are, you've got letters that have to go out, you've got accountings that have to be done, and you have orders that are issued from the court. So the protection mechanism is that, these judges are issuing orders, but they're doing it at the speed of the court system. With a living trust, you can do things a little differently and much quicker because you are the trustee of the trust. You stand into the original trustor trustee's shoes as the successor trustee, and armed with a lot of death certificates and a good plan. You have to have that list of assets. You need to know where the assets are, and you need to know what the liabilities are. And as long as that's laid out for you, then you can get through it pretty quickly.
Excellent. So generally speaking, then a living trust can be settled in a much shorter time. There is no statutory limit on exactly a date certain that it has to be settled out, because sometimes they're intended to last longer to distribute income for heirs, et cetera. But kind of to summarize, a trust can often be settled within 3 to 6 months, where the probate process can often be 3 to 4 times longer than that. But you have to be reasonable in how you go about it if you're the trustee. You can't just sit on
And the
things.
beneficiary.
And what about Shauna's example, where you had a trustee named who was just really keeping everything close to the vest and not really communicating with people and just kind of sitting on stuff? Do the other beneficiaries generally have a right to know what's in the trust?
Absolutely. And one thing, it happens often where someone will be dragging their feet or hiding the ball. And it's unfortunate, but that's where you have the mechanism, and you can petition the court and you can have this individual removed if they're doing it in some malicious way and not for some good reason. If they're acting unreasonable with regards to the administration of the trust estate, then you get a judge involved. And again, that's not the way a trust is supposed to work. So you want to spend your time as a person creating a trust. I tell them, spend your time. You don't really want to control the trustee so much, but spend your time thinking about who that trustee will be, the trust factor that you have in the individual to competently take care of what your wishes are. Because when the foot dragging starts and animosity is between beneficiaries, and you have one of the beneficiaries as the trustee, that's not really what the trustor's wishes were. So spend a little bit of time and make sure you have the proper person in that seat. All right, that's the power position.
And I can't agree with that enough, right? Because if the parents who have then passed away, if the parents don't put in the time to get that documentation as correct, as clean, as straightforward, here's my assets, here's my liabilities, right? If you make the trustee go hunt stuff down, it's compounding problems, just down and down and down and down the way. So yeah, I agree 1,000%. If you can do a little bit of work in advance, makes life a lot easier.
If you leave a little bit of a roadmap, it's going to make things a lot easier.
Yeah, and I can tell you firsthand too, because we do a lot of trust estate administration assistance with families here. And when the parents have taken time to thoughtfully contemplate their estate plan and have a trust and have information about the assets laid out and who gets what, the children are so grateful. They, you know, you're passed on now, but your children are so grateful that you did that. And, you know, it's immeasurable. And which kind of leads me to, I think Jamie touched on this as well, you know, and one of the questions I had here is, what are the characteristics in selecting my successor trustee or trustees for my trust? And should I name one at a time, or should I have co-trustees? Because people are asking, is it important that they be a professional or a lawyer or an accountant or somebody? But if my kids aren't any of that, and does it matter? Is that a requirement or a characteristic I'm looking for? What would you say to that?
Me?
Yeah.
Okay.
And
I
I
guess
got a question coming next.
unless you do have the person in the family that you trust with special knowledge, the accountant in the family, that kind of thing. You know, I generally like, if you have 6 children, that's a lot. But if you have 2 or 3 children, you can always make them co-trustees. And I kind of like that in many instances, most instances, even if one lives in Arkansas and one lives, you know, next door. What that does is it means that one child can't hide the ball. You don't get into that issue. Everybody looks at everything. Everybody's part of the decision-making process. If one of the children doesn't want to serve, remember, you're not forcing these people to take this position. You're effectively nominating them and you're putting them in the proper order, but you can't force them. They can always resign. So if you have 3 children and one is very seriously impacted emotionally by the death of a parent, or has their own stuff going on, or just had twins or something like that, or there's just crazy stuff going on in their life, they can always choose to say, I do not want to serve as trustee. I'm going to resign and let you do it yourself. But that makes it their choice rather than yours. So if things are generally equal among your children, there is not the special knowledge, not somebody who's more level-headed, not somebody that you know is the right person, it's not a bad play to have a couple of children serve as co-trustees. If you have a blended family, it's very nice to have one from each side. You know, you have one from mom's side, one from dad's side. They work together as trustees. Both sides of the family are represented. It can, you know, if they want to argue, they can argue about this stuff all day long. This is a money situation. They can argue about it all day. But you don't want somebody to be hiding the ball on someone else. At least everybody has representation.
Excellent. You know, you touched on something I want to come back to, but I wanted to get into another tax-oriented question. So, Shauna, let's say we had a living trust and the grantor, the settlor, the creator of the trust had passed away. People are wondering, what are the tax reporting requirements, and at what point do you need or do you recommend them filing an estate tax return? So we can talk a little bit about the income tax returns associated with the trust when the grantor died. And also, do we also have to file a separate form tax return called an estate tax return? What's that about?
Yeah, really, really good question. It's a really big question. So yes, when somebody passes away, so everybody who files a personal tax return right now files what's called a 1040. If you look at the form number, it's 1040, so a 1040. Generally, when somebody passes away, that person who passed away would have to file what's called a 1041, 1041. Now, that form has multiple options on it, depending on what kind of estate, what kind of trust, what was set up, what wasn't set up, right? So depending on what was formed, you would file that form a different way based on what happened for that particular person. Now, an estate tax return, right? So some of the other types of returns that you might see are a 706, which is a gift tax return, right? That's normally done during life, or a 709, which then is a part of that estate tax exemption. So all of those form numbers tend to go together in a way, right? They're generally all about moving assets, moving, things to heirs, that kind of deal. So typically your 1041 is going to be the trust type form that you might file.
Okay, and at what size estate is a 706 estate tax return generally needed or recommended?
Sorry, didn't realize I was muted. Sorry, y'all. Yes, with the 706, it's if you're making a gift over 15,000. So that's more of the lifetime that we're doing gifting during lifetime. So if the gift itself is more than 15,000, then we'd be filing a 706.
So if I want to give my son a house,
Mhm.
does he pay tax on that?
Depends on how much of your estate tax exemption is left. Normally, he would not pay tax on a gift. Normally, the person giving the gift during life would be the one that's actually paying the taxes.
So I have to pay the tax? I just gave him a house and I have to pay the tax? Is that what you're telling me?
Welcome to the federal government. Yeah, so
Does he at least get a step up in basis, when I die?
at the moment,
If I give it to him now, though, and then I die 5 years from now, does he get that big tax benefit? That's capital gain step up thing we talked about?
if you give it to him now, so if I gave my son a gift, say it again.
I give my son the house today.
Okay.
You're telling me that he doesn't pay tax on that. I do, because it's an extra gift, maybe. But, and then I die 5 years later, does he get the step up on the increase in value of the house I gave him 5 years ago?
Typically, no, because you already gave it to him. Once you give it to him, that's it, you've given it to him.
Right.
Yeah.
Yeah.
Now, normally when you give it to him, you're giving him something at the fair market value at that time. So whatever the fair market value was 5 years ago, right? If it was $1 million and now it's 2 million,
Yeah.
you gave him a gift at $1 million. So his basis becomes $1 million.
No, his basis is my basis. I paid two. Well, no, okay, Shauna, I got to call you on that one. I made the question way too confusing.
Okay, I'm
I
so sorry.
apologize.
Try it again.
I apologize. And I guess the core of what I'm saying or asking is, all other things being equal, is it, and let's just say I'm a beneficiary.
Okay.
Is it better to receive those highly appreciated assets from my parents as an inheritance after they pass away? Or is it better for them to give it to me now from a tax perspective?
Under the current law, typically is an inheritance.
Ultimately, that's what I was trying to get.
Okay. sorry, honey. There was lots of circular.
I know.
Yeah.
I confuse myself. I get lost in that little meandering
There's a lot
that
going
goes on.
on. Yeah.
Yeah.
Great question though.
And side note,
So-
I just want to correct myself. I think I got them backwards. 709 is the gift tax return. 706 is the estate tax return. My apologies.
Thank you. Okay, so we were just talking about 709, gift taxes, giving stuff during your lifetime.
Giving stuff
Okay.
is the 709. During your lifetime is the 709.
And if I give assets worth more than $15,000 to any single person, the person making the gift may be responsible to also pay some taxes, right?
Correct.
So that's the key to that 709.
Yes.
The 706 then, just to kind of wrap this section up and try not to confuse myself any deeper than I already have. A 706 is an estate tax return that can be filed after somebody dies. At what
Yes.
point or size of estate is it necessary to file that 706 estate tax return?
So generally we file it no matter what, right? And I guess that's me as a CPA, period. We file it to basically lock in with the IRS. We're under the exemption, over the exemption. We've given too many gifts. We've done whatever we've done during our lifetime. So generally we just file it, period.
Okay.
Some people don't file it unless the estate's over the estate limit. So I think that's going to depend on the tax on the CPA.
So it would be required if it's at least over the limit,
Absolutely.
but you consider it a best practice
Correct.
to file it regardless.
Yes.
Great, thank you for that. Okay. I wanted to, I'm gonna do a two-part question here. Number one, simple question. Can a stepchild be listed as an heir in a trust? That should be a fairly straightforward one.
Absolutely.
Good. And then you touched on, in the last segment, blended families. So why would it be important if you remarry and you both have children from prior marriages, constituting now a blended family? Why would it be important to do some estate planning together when that happens? And what are the downsides of not doing estate planning at that point in your life?
Well, honestly, everybody should do some estate planning. So for all of the reasons that we've talked about for everybody else in every other situation, those all apply. A few specific things about it. You can get into a situation where you can have heirs that begin, well, if both of you die and neither of you have a will, and then you start to begin to trace back what assets are whose assets, where they came about, how long have you been married, are there prenuptial agreements? There's a whole lot of stuff out there where you may find that the children of one spouse believe that their parent or family member, or however they're inheriting, contributed way more to the union and to that marriage than the other, and therefore they should get way more than the other spouse's children. You have a lot of infighting. It can become very expensive. You are going to involve courts. You are going to involve lawyers. And I'll tell you who's going to make the money. And when it's all said and done, it's coming my way. It's not going to the heirs. It's coming my way. And that's, and that's unfortunate for the heirs. One of the reasons that we do all of these trusts is so that the attorney involvement is minimized, if not eliminated. And that's really the best way to do it. So if you have a blended family and you think that there could be issues, look, there are enough issues involved with a nuclear, a nuclear 3-child family, let alone you start to bring in other people's children, and maybe they were all adults by the time that the marriage occurred, and some of them may not even have ever met, So you have a lot of different things out there that occur with blended families. It's not just, it's a second marriage and both of you are 26 years old and you each have 2 kids and you're raising them all together. That's usually not the way it goes. So it is best to make sure that if you have separate property issues, they can be addressed within the trust. If you have community property issues that may be distributed, what one family may say unfairly, but you believe that it should be distributed differently than across the board, it's your choice. It's your asset. It's your money. And you can distribute it as you see fit. And yes, to the stepchildren. You may not like your own children anymore. You want to give it all to your spouse's kids. You can do that. So
it was nicer to you, right?
But remember, that's your choice. And as long as you have a trust, you are directly, your intention is set forth within a document, a testamentary document, that you are going to include these people or these institutions or your pets. If you let the courts do it, they're going to do it based upon the statutes of California, which will not include anybody other than that. It's going to first goes per stirpes, and then it's going to be by intestacy succession. All
right, great answer. Thank you so much. I think we're coming close to conclusion of our seminar, but I would like to bring up and address something that seems to be on the rise in this country, and that's people moving from state to state. And there are some potential estate planning implications to that, and also some tax implications to that. So I'd like to start with the estate planning side, and then I have a specific tax question for Shauna. But is it necessary, if you move from one state to another, to redo or update your will or trust? And if you don't, does that make, if I move from California to Texas or Florida or something, and then I die and I'm living in that other state, does it void my trust or my will? Should I have changed it or updated it or redone it when I moved? What's the practicalities of that, Jimmy?
have an attorney in the state where you move, just look at the documents. Generally speaking, all the states are part of the Uniform Trust Act and have been for years and years. So I'm not seeing that the trust itself or the will itself would be null and void for whatever reason. Again, I'd have to look at the specific documents, but if you want to be protected, you do have states that are community property states, states that are separate property, states that are marital property, commonwealths. You have states that have different laws regarding how assets are treated among spouses anyway. And could it impact it? I'm not really sure. I'm licensed in California, and as far as California is concerned, I would like to look at the trust document from another state. Some states may have some weird things that they want in trust documents. I know that many states have some different things that they like to see in a will or a power of attorney, which we have not spoken about yet. I definitely get your powers of attorney, both for asset management as well as for health issues. Get them reviewed immediately upon moving to another state, okay? As for the trust or the will, you're probably going to be okay in most instances.
Good. But since you just brought that up, and you're right, we haven't talked about it. When you do a revocable living trust portfolio, what are the cornerstone documents represented in that trust portfolio, that particular estate plan? It's not just a trust, is it?
Well, it has to be the trust, obviously.
The trust, number one.
And some attorneys will just hand you a trust. You should have the trust, what's known as a pour over will. Think of a pour over will like this. You don't want the will to be used. If the will is being used, that means it's in probate. If you inherit if everything's in your trust, you inherit a piece of property in Iowa, driving home from Iowa, before you put it into your trust, there's an accident, that property is outside your trust for whatever reason. This pour over will would then be lodged in Iowa, and it basically says, hello world, I have a living trust. If anything is outside of my trust, I'm leaving it to my trust. So it effectively pours it into the trust. We want the trust to administer everything. And if everything's titled to the trust, then the pour over will really isn't going to have a function. But it is a safety net document, as is the durable power of attorney for assets. That document is used while you're alive. Let's say you're that same scenario, but you're not gone, but you are alive and you are no longer competent or you're incapacitated. Your power of attorney can be used to take that Iowa property, put it into the trust immediately while you're living. That way, the pour over will is not used. It's in your trust. It avoids probate. Another safety document. In a perfect world, it's not used. One of the most important documents that has nothing to do with the trust or your kids or your finances is the power of attorney for healthcare and your advance directive. That takes care of you, and you're alive and you need help and things need to be done. So be very careful with that document. And my advice, and other attorneys will have different advice, and other people or clergy or many people may have different ways to look at this, but I would prefer that you do not have all of your children listed on your power of attorney. For assets, let them deal with that. For your health care issues, have a primary person dealing with your health issues, because if they don't agree, that's not a time for a medical professional to force you into court so that a judge decides who's going to do what. I would, those are the cornerstone documents. If you have a good estate planning attorney who is worried about your kids, then they're going to include other things. They're going to include the funding documents to make sure everything's funded. Some instructions for the successor trustee are very nice for them to have, as well as some certain schedules where you can write down your assets to kind of give them that roadmap. That you have to monitor a little bit. But other than that, those 4 documents are the big ones.
Great, excellent. I think everybody needs to understand that because it's super, super important. All right, Shauna, you ready for this interstate traveler tax related questions now?
I'm ready. Let's do it.
I think there's a couple of questions here. So let me see if I can phrase this without doing what I did earlier and confuse everybody. Let's take earned income versus passive income. If I move to a different state, and let's just take retirement. I think the questions here is really I'm retiring now, and I've got my investments, and I've got Social Security, a pension, and I'm drawing income off of my savings and investments. And I move, let's say, from a pretty high tax state like California to Texas, Nevada, Florida, one of these other states. Arizona's pretty low too. How much tax am I paying in California? Am I paying everybody? How does that work?
So giant smile, because again, the states have little arguments about this, okay? California, since you brought up California will continue to try to tax that income, whether you move or not, because they look at it and say, you earned that income here, we want our cut of that revenue. Different states may not do that. So there's other states that say, you move, that's fine. Go pay tax over there. Nope, no problem. So it's absolutely dependent on the state. So I would highly, highly recommend that you look at your current state rules and then the rules, because you might actually get double taxed. Your current state may tax it and your new state may tax it. And they may not have credits between the states. So you might actually end up paying double tax on it.
Interesting. I had always heard that, let's say I had an interest bearing, well, like my pensions and Social Security. If I move to a different state,
yeah,
don't I pay just state income taxes where I'm living and domiciled and I'm a taxpayer there now? Social
Security is a federal level thing, right?
Right.
So the feds will control who pays what, and the feds have said, yes, that's fine, whatever state you live in is perfectly fine.
Okay.
But if I have like a retirement plan from a company, like a pension, right, and they're paying me out, some of the states have said, no, that's pensions. It's going to stay with whatever state it is.
What about like savings or annuities or a brokerage account that's just paying me interest, just interest and dividends, and I've moved?
Yep. So savings, you're good, right? Because the bank account, it tends to be a federal bank account, so that's going to move. So the answer here is it depends on the type of income. Is really the big answer, right? Okay. Interest can move. Annuities, maybe. Is that a state annuity? Like where did it come from? What's the base of where you got that revenue from? Pensions can go either way. So for example, Louisiana doesn't tax pensions received by state and government at all. So if you had Louisiana, you want to keep Louisiana, right? So it's very dependent on the state.
Interesting. So there's a lot of shopping that can go on when you're trying to decide.
There's a lot of shopping.
Where you want to go, and including, and we won't go down this rabbit hole, but a lot of buzz about Puerto Rico and tax haven type stuff. And people. So
that's the whole next webinar, right? Greg,
that's the whole, yeah, that'd be a whole thing. And I still have to brush up even more because every time I look at that, something new pops up and I go, this is in the United States, right?
Mm-hmm.
Really?
Puerto Rico and the U.S. Virgin Islands, baby. You want to move and live there for a year? We're all over it. All the good bits.
Yeah, I kind of like the weather. It sounds pretty good. So, all right. Well, just a quick follow-up, Shauna. Somebody asked, you'd mentioned that, if you have 3 rental properties or 10 or whatever, then that constitutes a business. Yeah. So somebody chimed in right away and said, do you need to go get a business license if you own 3 pieces of investment property?
Yeah, it depends on the state, right? So I can speak for Arizona off the top of my head. Yes, okay. If you have 3, you have to get a business license. So guys, I think the biggest thing here is there are CPAs that work across the country like we do, right? I'm a CPA, we work with all 50 states, but there's also CPAs that specialize in California or New York or Pennsylvania or wherever you are, right? So if you're going to be moving, if you've got multiple things in multiple states, right, you probably want to work with a CPA that can do all 50 states, or at least the states that you have stuff in. Does that make sense? Like there's a lot of people that have a lot of things all right around the Northeast, right? So double check with your CPA and just make sure, often you don't have to completely switch CPAs, but you should bring a specialist on board to talk about the different pieces and how they fit together. So.
Very good. Very good. Well, listen, guys, I think we've kind of come to the end of our webinar. This has been tremendous information, and I want to thank all the participants for throwing some great questions at us. I've been doing this for better than 25 years, and I learned a couple things today as well. So I love it. I love it. And I hope everybody else learned 1 or 2 things as well. I want to thank Shauna, the tax goddess here for taking this time. I know how busy you are, and I appreciate all your input and your friendship and support over the years. Jimmy, known Jimmy for 25 years. He's been a rock and such a huge support for our company and our clients. I want to thank you both for taking the time today with us. And, maybe we'll get together and talk about Puerto Rico some other time. But, I really appreciate your time. I hope you guys have a happy holidays and be well. Thank you so much.
Happy holidays, Greg.
Okay. Bye for now, guys.
Bye.